Good morning, everyone. I think that was it was good yesterday with the subgroup doing introductions. We have a couple of new members today, and probably good to just do a quick intro once again on this. Let's start with Representative O'Neill.
Thank you, Representative Marion O'Neill. I am in my 5th term. I've been on the Public Safety Committee every year since I was first elected. I've worked in a lot of things about sexual assault, harassment restraining orders, OFPs, sexual violence and domestic violence and all that sort of thing. And so this topic has come up quite a bit in my work in the last 9 years. And so when we did the CSC rewrite, this was a recommendation and we actually put it in legislation, which is where we are today. So Representative Kelly Moeller and I worked really hard on putting all those pieces together. And we really want to take a comprehensive look at the list and see who's on it, who's not on it, who should be on it, and all the different aspects that we'll be discussing, including this subgroup. So I've been a part of all the subgroups thus far. Thank you.
Okay. And then let's go to Brian Heinzen.
Morning, I'm Brian Heinzone. I've been with the Department of Corrections for 23 years. For the last 17, I've been in the Risk Assessment Community Notification Unit and supervising psychologists in that unit for the past 10 years, dealing with registration and end of confinement review committee, community notification issues the entire time. So, morning.
Okay, and then one of our co-chairs, Angie.
Hi, Angie Keys. I lead the Civil Sex Offender Unit at the Attorney General's Office. So I advise the BCA on registration issues and work with them on registration cases. I defend the Department of Corrections on risk level appeals or work with them on issues related to those appeals. And I do the Civil Commitment of Sexually Dangerous People for about 80 counties, 79 counties around the state, along with my team.
And then Sheriff Heck.
Morning, I'm Sheriff Troy Heck from Benton County. I've been the Benton County Sheriff for 6 years now. I've been in law enforcement with Benton County for 27 years, and I'm here representing the Minnesota Sheriff Association.
And Sheriff Heck is also one of our co-chairs of the working group. Patty.
Hi, I'm Patty Wetterling. I've been involved with child safety issues for 30 years. I'm also a consultant with Fox Valley Technical College. I provide victim impact in their trainings. I've been concerned about the sex offender laws since we were the first to pass the registration in Minnesota, and it sometimes feels like the intent got sort of hijacked and has gone off in a lot different directions. And I'm just trying to take part in assessing where are we at, what's working and what needs to change.
Okay. And then Renee. Do you see that unmute button? Okay.
I do. Thank you. Good morning, everybody. I'm Renee Merkins. I'm a division manager here in Hennepin County. My career has been as a probation and parole officer since the onset. I worked in Dodge, Fillmore, Olmsted County, Dakota County, and now I'm in Hennepin County as a manager. So I manage over 9 units. 5 of those units, 3 are supervised release, 2 are intensive supervised release, and I also have the probation unit of individuals convicted of a sex offense and those agents that are supervising those clients. So thank you.
And then Karen.
Good morning, I'm Karen Jazuski. I am on the working group as the Minnesota Judicial Branch Representative. I'm in the Legal Counsel Division at the State Court Administrator's Office, and I've been there for, I think, over 15 years.
Okay. And then Jim.
Jim Fleming. I'm the District Public Defender for the 2nd Judicial District. That's in St. Paul. Stacy Bettison asked me to sit in for her today. She's in trial in Sioux Falls and couldn't be here. So I'm in her place.
Then Senator Ingebrigtsen.
Morning, Senator Ingebrigtsen representing Senate District 8, which includes the larger populations of Alexandria, Fergus Falls, Otter Tail County, Douglas County. Former sheriff, 34 years in law enforcement, been 15 years in the Senate. Almost all of those 15 years I've been on the Judiciary Committee. I do now serve on it as well. And as I said earlier, I was around when the offender program notification started. Back, I believe, with Will Alexander. Those may remember him. He and I had a couple of different notifications. So I'm always been interested in this and want to make sure that it's it serves the public the best we can. So thanks.
Okay, and then we have one public observer, Mary.
Good morning. My name is Mary Cardinal Peterson. I am presently the chairperson for the Minnesota Corrections Association Legislative Committee. I am retired from the Department of Corrections, but my career has involved working at the sex offender treatment program as a release planner and therapist. And prior to that, I was a probation and parole officer in Dakota County, and I supervised people convicted of sex offenses. And thank you for letting me keep up on what you're discussing and what your concerns are.
Okay, and then I'm Mark Bliven, along with Olivia Anderson. I'm one of the coordinators of this working group. What we do is the background work to keep this working group going. I have been with the Department of Corrections for about 21 years. Prior to that, I worked in education with the Board of Peace Officer Standards and Training. Olivia.
Well, we also have two other members.
Oh, I'm sorry.
This end of the shop. Katie.
Katie Myers with BCA. I've been here for about 23 years or so, working most of the time in this unit back when it was a sex offender registry and turned into the predatory offender registry. I supervise the civilian side of the registration unit, and we are tasked with making registration determinations in consultation with the Attorney General's office, as well as training law enforcement on our systems, as well as changes in the statute over the years.
Josh.
Hi, Josh Floral. I'm the special agent in charge of the predatory crime section. I've been at the BCA for 24 years. Been in this section as a supervisor for about 12 years, I think. And our agents in this section, there's probably 15 of them total, are responsible for investigations of people who are not compliant, both level 3s and others. And we also do the internet crimes against children as part of our unit as well.
And I'm Olivia Anderson. I'm one of the senior legal analysts here at the BCA. My duties include assisting generally with everything from contracting to warrants to compliance with POR statutes. So I work with Katie, Josh, and Angie on this. And I am one of your co-leads. So if you need anything, please let us know.
Okay. And then Olivia, if you wanted to cover the agenda.
Sure. So for those of you who have been in subgroup meetings with us, this is going to sound oddly familiar again. So we really just want to get down what folks are interested in chatting about with regards to methods so that we can plan out the remainder of our time together, realizing that we have a little less than 2 months together before we need to begin getting into some of the final determinations and concepts. So this time is primarily for folks to discuss the topics that they would like to dive into over the next couple of months, so that myself, the chairs, and Mark can work on setting future agendas and be sure that we are on track and on time with any and all recommendations. So if there are any topics that folks would like us to be addressing in the methods subgroup, I'm happy to resend the language as to what this applies to. But generally, we want to discuss how the statute is applied to offenders and what ideas you all have as to what we should discuss in terms of deeper dives. Anybody want to start?
Well, I can say that Jim brought up some things yesterday that we talked a little bit about in one of the other subgroups. I think there are kind of two different methods to be considered here, at least. And one is if the same set of circumstances remains in the statute, at least to some extent, you know, a way for the court, is there going to be a way for the court to address that as part of any kind of sentencing or court proceedings with respect to the registration offense? And then the other thing is that the initial group, the criminal group that kind of instigated this group, they had suggested a process similar to an expungement process where after somebody's required to register down the road, they can potentially challenge registration or ask to get off the registry, I should say. So I think those are kind of the two main kind of process issues, at least from a challenging standpoint. Jim, do I have that right?
Yeah, I mean, I think in a broader framework, yes. I mean, I don't know that anybody's agreed on the particulars. What we've noticed when we were doing the other work group is that there was a petition method where someone could petition to get off the registry after having completed treatment, being able to submit evidence that says they're not, I mean, that they've successfully treated. And I mean, the language would have to certainly be discussed, but Minnesota doesn't have anything like that. There's no option for releasing. With respect to the same set of circumstances language, I mean, we're the only state that has that requirement. And, you know, we certainly were interested to know how many more cases are included on the registry because of resolutions that resulted in same set of circumstances language. And I'm certainly, I mean, I would prefer to get a situation where the person who pleads guilty to a registerable offense has to register, which would be clear. But I'm also open to an option where there's some finding by a judge as to whether or not you are in the same set of circumstances that would require registration through as a part of the sentence. But I mean, so that was the discussion points that we discussed yesterday. So I mean, I hope that sums it up.
Representative O'Neill.
Thank you. They touched on kind of a couple things I was going to bring up. And I think at the legislature, one thing that we would be open to considering would be, right now it's a strictly administrative process. And it may be helpful if those on the call that actually do that could explain to the group the intricacies of that, because of course it's the Attorney General's office and BCA that coordinate and make that determination. So one option would be to remove the administrative process and go to a judicial process, which is what Jim just said. And the other is kind of the off ramp. So there's an option to petition the court to be removed from it. And in my work at the legislature, you know, obviously we hear the case scenarios that are very extreme because they rise to the level of us dealing with it. Juveniles come up an awful lot of, they've committed something that wouldn't really, by normal standards, wouldn't be considered predatory, maybe a very stupid decision, but not necessarily predatory, and there just isn't an option for them to not be on it. So these are all complexities. But my ask is, that Jim said all that and Angela said all that, is maybe whoever does the process that's represented here could kind of explain what did they do? How do they walk through that determination as it is an administrative process right now? That would be helpful for me to hear at least.
Well, so what we do now is that the BCA will ask us, or me generally, I'm not saying the only one who ever advises, but I do most of it. So they will usually ask me if there's a case where it's not clear from the statute the registration applies. So for a same set of circumstances case, or like an out-of-state offender, federal offenders, things like that. And so I will advise them based on the statutes, the other state statutes, the federal statutes, the case law that applies to same set of circumstances or out-of-state offenders, and advise them with respect to whether that registration can be defended or not, and why. So like for an out-of-state offense, I might say that it's similar to our, at least our 4th degree criminal sexual conduct, or our 3rd degree criminal sexual conduct, or kidnapping, or whatever. For same set of circumstances, you look at the factors in the Lopez decision, and now in the Berry decision, it's been reaffirmed. But whether it's the same time frame, the same persons involved, the overlap with respect to those types of things. So it's a legal analysis and advice to the BCA on whether our statute would apply to those, versus an administrative process like for risk assessment or whatever.
Yes, and from the Department of Corrections, it's been critical over the years that we emphasize to everybody within the DOC that we always, in every single circumstance, defer to the BCA, basically to Katie, with assistance from Angie, on whether somebody is subject to registration. We never make that decision. We always defer to them to give the final answer on whether somebody is subject to registration.
Could I ask what the thoughts are in this group of moving from this administrative process that you just described between the BCA and the Attorney General's office to a judicial proceeding as part of sentencing?
So I kind of mentioned yesterday, and I said sentencing today too, and it makes me a little nervous to do. I would want to be separate from sentencing because this is a civil regulatory statute, and I think we're going to get in the mud a little bit if we make it part of sentencing, because it's a collateral consequence of sentencing. But as part of the court process, I mean, I guess it would depend on what exactly the recommendation was for that, if that would make sense or not, what the language would be. I don't think it's a horrible idea. I just don't know enough about how that would work. I looked at the language from the subgroup that kind of tracked the expungement language. And I mean, it seems like decent language as far as challenging things, but we haven't really talked about any language at the front end. If considered circumstances remains in the statute, what that language would look at for a court considering it. Yeah, and yesterday we talked about, would it be similar to the language that requires courts to make a, civil commitment determination? So I think we would just look at some language. And Jim, I don't know if you would have anything in mind on the front end, but or if you could point to something from another state, maybe. I mean, I guess I don't have the same set of circumstances, so that wouldn't work. We could maybe look at some of the language for some of the other things the courts do make determinations on and see if there's something that would be helpful.
Can I just add something? I don't have the ability to raise my hand since I'm connected with Olivia. But just a piece speaking from the registry side of things and over the years watching things, one concern that I would have about that type of a process would be the disparity between people who hire an attorney who are court appointed. We'd have some, you could have technically co-defendants, one be getting required to register, one not. So it's kind of that whole equal system applying to the offenders. That would be a concern versus the process that we're doing right now where, Angie looking at it saying that we could defend, it would most likely be the same for both of those defendants or, anybody involved in the process right now. Whereas this changing that to allow for the courts to do it could cause an unequal system, if you will.
Okay, Karen.
Well, I would probably have to start by disagreeing that shifting it to the courts would make it fundamentally unfair, but we'll set that aside. This is a whole new idea to me, so it's obviously a lot to think through and the concerns. I would agree with Angie's first comments. I think making it part of sentencing it adds a whole new dimension. Now you've got attorneys briefing it, more appeal issues, more judicial time. I assume the fiscal note would not be small. We've struggled with getting our hands around how many are there. I think the data would have to really be looked at to know the impact. But again, if it's going to be collateral and it's going to stay collateral, yeah, I would have a lot of concerns with making this part of the district court process. I think the time and effort, and like I said, appeals would really be an exorbitant price tag. That said, and I too would have to see the language. I can somewhat see the logic of having a petition process for being relieved of that. I don't know if it's not the same, but obviously people can do that for getting their firearms rights restored. As you said, with expungement remedies, there are some of those that might make some logical sense. Not saying they too wouldn't have a fiscal impact, but I would have to see what it says. But this is all a lot for me to absorb. So to just kick this off with, should we move this all to the judicial branch, has me very scared right now. Slow down. Thank you.
Sheriff Heck.
I'd also echo the concerns about consistency and fairness. I think that you take this process that's being right now administered by some people that have a lot of specialized skill, knowledge, and understanding, making recommendations based on a lot of research that they have internalized. And now you're going to spread this duty out across the entire judiciary to judges that may or may not have the same type of experience, knowledge, skills, and you're going to expect them to somehow come to consistent findings. I think that the challenge to that process would be you'd have to give some very specific language in the law that these judges could refer to do their best to make consistent decisions. I think that's a daunting challenge.
Okay, Jim.
I don't agree that because of the bureaucratic nature of the existing system that it's fair at all. Looking at it on this side, we find it to be unbendingly bureaucratic, which I think in many respects speaks very much to its unfairness. I've got a guy that came into my office recently. He's 32 years old. He pled to as a juvenile when he was 13 to a third degree. He's still on the registry. He can't get off. And of course, it's just this same bureau. They just keep putting it on, and there's no ability to listen to any equities or merits about whether somebody should register or whether or not someone is even sort of dangerous in a sense that they should be. And then with respect to the special knowledge of the data, we've asked for data and we're told we can't get it. So I'm really having a hard time sort of accepting that there's some kind of special data out there that people can't seem to access, whether or not this system one is doing anything with respect to as an efficient law enforcement tool. It's certainly, I mean, I get it that law enforcement can look at the registry when there's an offense going on, but I'm not aware that someone said, well, because of the registry, I was able to solve a crime. This provision isn't nearly as effective as the requirement of having someone, a felon, provide DNA. That has been, from a law enforcement standpoint, very successful. People from the outside are looking, we see essentially a bureaucratic registry that just fights really hard to keep people in the system and has got the most, the easiest way to get into it with the same set of circumstances language, which I point out again is the only state in the country that has that language. And you can't even tell us how many people are on the registry because of that language. So I'm just someone from the outside looking in. I see this as a bureaucracy trying to protect its bureaucracy.
I don't have an opportunity to raise my hand, but I'm just, from a law enforcement perspective, especially in our unit here, which we are by statute mandated to immediately investigate any non-compliant level 3s, and our internet crimes against children task force that we run out of the unit here. We use the registry all the time in terms of when we're finding people, and quite honestly, a lot of the our cases were with child sexual abuse material or child pornography blend over, or people who are on the registry for a previous conviction for CSAM, and some sex offenders, that those two bleed over all the time. And my agents are on the registry using it to locate offenders all the time.
Renee.
Yeah, I have a couple of different thoughts. So arising out of the same set of circumstance, I have a hard time from the probation parole perspective with how that would shift to the judicial branch. Just what would that look like, particularly for those incoming cases for out of state cases. And again, I have the same concerns about the appeals and that backlogging the system, so to say, and what that would look like, and the unfairness of that. We know that some of our clients that we serve very well can afford those private attorneys, and then some cannot. And then they would be looking at a public defender, and the fairness with all of that just really concerns me. The other piece that I'd say, and Jim, I line up with you on this, previously in my work, indeed, people have to register for a long, long time, and that is really impactful. I've had kids where they've made bad decisions and choices who are still registering today. I've had adults where they have committed an offense, taken responsibility, successfully completed programming, married with children, and still registering. And again, the impacts that has on those individuals. So I line up with you there, Jim, as far as your concerns with that piece of it. And I certainly am into or supportive of some kind of a process in which somebody can petition, can go before a board, whatever that might look like for them to then be removed from that registry at some point in time.
Representative O'Neill.
I think Brian might have had his hand up before me if he has more. No. Okay. This is all really interesting. This is the same kind of conversations that we've had at the legislature, where you've got the defense attorneys and public defenders like Jim and others saying exactly what he's been saying. And and then those that are actually administrating it saying the same thing. So can we talk a little bit about, and so I don't know that we'll come to a resolution other than the fact that there's a problem, and it's because it's administrative, there isn't an opportunity to petition to not be on it. And so I know that's a big issue, but can we talk just a little bit about like kind of the ROI, the return on investment for having somebody on the registry? And I think I didn't catch his name, but the gentleman at the BCA that said he had solved a lot of cases. And I think that's, you know, we have to weigh at the legislature the collateral consequences and the detriment to someone being on it, including where they can live, their possibly a job that they cannot get, and so on, versus them being on it so that we can solve crimes, which was the intent. And I'm wondering, I'm sorry, I don't know the gentleman's name.
Josh.
Josh, there we go. I could just barely see him in the corner of the screen. Josh from the BCA, or maybe others want to talk about the benefit of the registry and how they've solved crimes, because we certainly have a lot of people on it, 19,000.
I just, without giving too much away, I mean, I have a case right now, one of my agents is working on where the registrant is being investigated for another crime, and they're on there as a level 3 predatory offender, and we're able to locate them by using the registry because he's compliant, so we know where that person is at, and we're able to keep the investigation going there. That gives his phone number and some other items that we use as part of the investigation. And that's, I mean, that's just an anecdotal thing, and one that's going on right now. Like I said before, there's a great bleed over for people who are on the registry, and I don't have like recidivism rates, but I would say half of the people we're investigating for child sexual abuse material or child pornography cases are on the registry already for either a previous CSC or another child pornography case earlier. So, I mean, it just helps us know what we're getting into when we're going in there, because I tell my agents that there's always people who this is their second time through. I feel they're a little more dangerous and have some more skin in the game, and so we need to investigate those a little more carefully, or when we're doing it, to go in to do some enforcement action, it takes us a little more time to plan that out. So I think it is very helpful. It has been very helpful in those terms. I just do have a question when people are saying to petition to get off the registry. Are we talking before the 10-year registration period or after their 10-year registration period, or when are you asking for people to petition to get off? I want a clarification on what we're asking for when you're asking for that. Thanks.
Okay, Brian.
I just want to jump in and echo a lot of what people are saying. I know Jim and Renee talk about, I definitely am in favor of some type of ability to get off the registration, whether that's prior to a 10-year initial registration period, for sure related to lifetime registrants. I don't know the exact mechanism. We're talking about a lot of different things here. And maybe, over the course of time here in the next few weeks, hopefully we can narrow that down. But I think just as a general broad perspective, I think the ability to be removed from the registry is vital. Also on the front end, again, don't necessarily have the mechanism for how this would happen down, but under same set of circumstances or other individual case situations, the ability to register or not register may be more of an independent decision. In my unit for risk assessment and assignment of community notification risk levels, there's a process for guys who are assigned to risk level 2 or 3 to get that risk level reassessed if they meet certain criteria after a certain number of years, or if there's agent, it can be requested through their agent in the community. If they've met criteria like completed treatment, stable housing, no other additional crimes in the community, these kinds of things. Some of it is bound by a certain number of years in the community, some of it is not. And we look at it on a case-by-case individual basis as the whole person, a broad risk assessment is completed, and make those decisions. And then a committee, of course, actually assigns a risk level. A lot of guys end up being reduced after several years in the community from a 2 to 1, a 3 to a 2, those kinds of things. So I think if somebody has demonstrated, even within the 10-year registration period, that things are going very well, and from a risk assessment standpoint, that can be something that can be looked at. So again, the mechanisms for how that's going to happen, I think we can have some additional discussion, but just wanted to chime in on that.
Sheriff.
Other topic I'd like to touch on with regards to is the registry effective or the return on investment. I think that there's also a crime prevention aspect to this. Again, and this is my opinions, my thoughts, since we're lacking good data on this, and also it's hard to prove something that hasn't happened. I do believe there are people on this registry whose offense pattern is going to be altered or stopped because they know they are on a registry and they know that their name is going to pop up in front of law enforcement if they continue this behavior, and it's going to serve as a further disincentive to their continued criminal behavior. The registry also provides law enforcement with intelligence that we would not have otherwise, to look at situations that are maybe reported to us that someone finds strange or odd. Perhaps there's an adult that's got an unusual interest in children, or maybe there's a citizen that calls in and says, you know, I have an uneasy feeling about this relationship that I'm seeing. With the registry, we can check to see, well, is this person someone who's on the registry because of past criminal behavior? And if so, then we could perhaps intervene and prevent a crime there. Whereas if we didn't have a registry, if that person wasn't on there, it would be very difficult for us to take any action.
Karen.
Yes, I think my comments are more relevant to, Brian had already touched on this. I was also going to challenge the notion that these are somewhat unreviewable decisions and, you know, that nothing can ever change. I know Angie walked us through quite a bit of case law. So I assume, as any administrative decisions, these are directly appealable, and they have been appealed. So there is, I don't know if it's maybe just not formalized enough, and that's the concern, but clearly the decision to require registration or not has been appealed, and then a panel of judges does review it. So just wanted to add that. And then one other thought that I had not had the first time around, which was the extra added complexity of these out-of-state offenders. I hadn't even thought of that. Trying to bring those before the judiciary is really difficult. That creates a whole new petition process, which I assume the state would have to take the lead on, even get those cases before the court. So now you're having to petition the court to require a registry for someone that's not even on the court's radar. Whereas now you just handle that as sort of a supervisory administrative decision. That was it. Thanks.
Great. Jim.
With respect to out-of-state registry, it would seem to me that they would have to go back to the state that they originally required to register in for relief. I mean, that makes perfect sense to me. With respect to, I mean, I put a information in the chat. I'm not, nor is anybody in my group looking to eliminate the registry. There are people who've committed offenses that need to be on this. I'm not suggesting this. There is this group of folks who are on there who are same set of circumstances, who really, we don't know anything about how effective this is. With respect to Sheriff Heck's response about it's an effective tool that we could check, law enforcement has access to people's criminal histories. They have law enforcement contacts that they have access to. I'm not convinced that this is an effective tool. And I only say that because I've had cops tell me this. It's not. Now, everything we're going to be talking about is going to be anecdotal. We don't know.
Angie.
Isn't it nice that I raised my hand for
Yeah.
I guess a couple of things. Maybe this is somewhat anecdotal, but it's, I think it's pretty good data. But I would say the vast majority of the same set of circumstances cases that we look at end up being same set of circumstances. So from the use of court time standpoint, as far as that kind of analysis, it seems like most cases, you know, that doesn't end up being an issue as far as whether it falls into the same set of circumstances of the charged offenses. Occasionally, there are cases where they're different. They have a different kidnapping victim than the robbery victim or whatever, but, or, you know, it's a different time, like later in the day or the next day, they do something and it all gets charged in the same complaint. But I just wanted to say that the vast majority of the case, when we're looking at that, you know, that is something that's not really disputed. And I talked about this yesterday, but some of you weren't on the meeting yesterday, but as Karen was saying, you know, people do challenge this sometimes during the criminal case. They challenge it in failure to register cases as to whether they're required to register in the first place. They challenge it through risk level appeals as to whether they're required to register and whether they should have gotten a risk level appeal. They challenge it through the lawsuits as to whether they should be required to register in the first place is one of the issues. So there are ways that it can be challenged, and it is challenged, and that is why there's case law on the issue. So I just wanted to kind of reiterate that, because for the people who weren't on the call yesterday about that.
Representative O'Neill.
Thank you. I just wanted, if Josh could let us know from the BCA, like you talked about half of your cases that the registry was helpful. And I'm wondering, like, how many cases would that be? Like, how many cases are you working on right now? Or do you work on in a year?
So just for the Metro, for example, I've got 9 agents working out of the Metro working predatory offender registration cases, as well as internet crimes against children cases. And I'd say each of them is actively working on 3 cases at any given time that they're following up on and getting ready to arrest offenders. So that's, 27, 28 cases over the course of a couple months that we're working on. Like I said, the registry, it's a lot of times, some of it, and the one Jim was saying that we have access to criminal history and stuff, but some of that stuff doesn't really pop up on you. You don't run in that unless you have you're looking for something there for criminal history. But for the registry, it really helps to also for a pattern of behavior, and you're figuring out what the guy has done in the past. I mean, we just arrested someone last month who had just completed his 10-year registration period for a CSC, and we picked him up on another child sexual abuse material case or a child pornography case. So I mean, and working in this realm or in this part of law enforcement for specifically all the time, we use it quite a lot. I don't know, generally speaking, does law enforcement run into a lot of things? No, but for the investigators doing CSC cases or child pornography cases, the registry is very helpful for some of these predatory crimes.
Brian.
I think a lot of this brings me back to this idea of this risk needs responsivity principle that we talk about a lot in the field of psychology, and the risk principle in particular is, we give our best, most intense stuff to the highest risk, highest need guys. And some of the other folks, we don't need to give them as much supervision, as much treatment, those kinds of things. It's not that one size fits all kind of approach. Right now, I know people are convicted of, charged and convicted of certain crimes. It's kind of an all or nothing thing. But as much as we can individualize things, like from a risk assessment standpoint, I think resources and time, supervision, management, everybody is overworked and has a lot to do. If we can focus on those that we need to focus on and let the others kind of go about their lives, whether it's getting off the registry early, getting out of treatment after, or not even being recommended for treatment in some situations, that's the ideal way to do it from a resource standpoint and a risk standpoint. I know we all have cases. It's not just about same set of circumstances I've found either. We have cases of guys that are convicted of criminal sexual conduct 3rd degree. But if you look at what that conviction involved and then their overall history, maybe it was a statutory type offense when they were 18 against a 15-year-old girlfriend. They have no other history of sexual crimes or even criminal history in general, maybe. Does that guy need to be on the registry for 10 years? Potentially not. Does he need to be on lifetime? Those kinds of things. We also have, I've seen same set of circumstances situations where a guy's charged with CSC1 and kidnapping, convicted of deprivation of parental rights out of the same set of circumstances, looked at his overall case, a lot of other allegations and things going on in his history. We assigned him a level 3. He subsequently went out and reoffended against a 12-year-old girl at gunpoint and got convicted of CSE 1. So I think everybody has cases where it kind of goes both ways. And that's, again, it's difficult from an individual standpoint, but that's, again, my 2 cents.
Yes, Renee.
Yeah, I would just like to add to what Brian has said. So, and to what Jim has said. So Jim, I would say from a probation parole perspective, we do use that registration information, the secondary address, vehicles, like the license plate of vehicles, that kind of thing. And commonly when someone would go like on an abscond status, we are using that information. We're providing that to law enforcement. They have access, but commonly we're collaborating with them about that. So I'm not advocating for this to go away by any means, but I definitely will join up with Brian. We do risk needs assessments, and when they are lower risk, that determines our level of supervision for individuals, meaning they've completed treatment, it's not predatory-like behavior, they're showing stability, pro-social skills and activities, and a lot of different things. So I think under some circumstances, we could determine who would be eligible for possibly petitioning or whatever that might look like based on their circumstances and what the situation might be.
Patty.
I think that risk assessment is really getting to the heart of what we're talking about. I guess I'd like to know more data on those who do reoffend and what the first offense was. And at one point I had read that the pornography aspect, depending on how egregious it is, can be a better predictor of the likelihood of reoffending than past crimes even. So, you know, it's like, do we have data on that, those who reoffend, what was their first crime and what was their, you know, are we doing a good job with that? And I'm really happy to hear that it's a really useful law enforcement tool, because that's what it was created to be. The challenge is when the challenge for me has always been with juveniles, because we all know kids do stupid stuff, and the punishment for them is much more life-changing, and that's my one concern is dealing with that. But I guess I'd like to know 2 things. You know, are we doing a good job of assessing the reoffenses and what, so that we can use that for further evaluation? And the second thing is that there are states who have a process for getting off of, for applying to get off a registry. And I think that language would be really helpful to see if some of that might be something we could add to Minnesota. That's all. I have a lot of questions. This is just raising everything you guys have worked on for years for me. So thank you.
Sheriff Heck.
In listening to the conversation, I think that it's safe to say everyone here agrees that the right people should be on this registry. And I think the challenge that we have before us is, how do we come up with a system that finds who these right people are? And I think that's a very daunting challenge for all of us. I don't know if we can focus our efforts on figuring out what that system might look like or how we get to that system. I think that we'd be doing everyone a service.
Angie.
Hi, you know, I was just going to mention, we talked about this earlier, that this language that the other group had, somebody asked about the petition timing. But anyway, Mark has that linked on our website, the petition for relief, at least the language that they initially came up with. So if you just want, maybe before our next meeting, if people want to take a look at that, just trying to see, you know, their thoughts on that language or similar language or whatever. And then I don't know how soon I would be able to look at other states, or if somebody else wants to look at other states to see if there are other kinds of ways to petition off, but I do think that might be helpful to kind of see what other states are doing, if anything, on that part of it.
I know when
Jim, I
I'm
don't know
being
if you
called
know
upon. Can you,
Yeah.
Okay,
Mark?
yes. Yes,
Okay, please unmute me.
you are.
Can, I know when I'm being called upon, I will pull up research on the 50 states and try and figure out what petitions are out there and bring it back to the group for folks to see, along with some of the additional research that the other groups are doing. So I will do what I can as soon as I can.
Just so you guys know, that proposed language from that past group, the statutory reform group, Mark has it on our website. The link to it is in the first meeting. So you have to go into the first meeting and then the link is in there, just so, because it's like, I didn't find it right away because I wasn't sure where it was. So just so you know, that's where to find it if you want to look at it.
What we'll probably do is readjust that and put one page for all the resources and try to get it in some kind of order so that you have one place to look to for all the types of documents now that we're getting more of those. Okay, was there anything else? Patty. Oops. There you are. You're good to go.
With the internet crimes, can you give me a thought on how many of those are juveniles who are committing those? Specifically with the ICAC?
With ICAC, we don't run into a lot of juveniles, quite honestly. And for the most part, unless it's something egregious, we're not, for kids, we're more advising and trying to, tell them what they're doing, talk to the parents kind of thing, more than anything. A lot of cyber tips that we get that are just children self-producing or putting inappropriate videos of themselves on the internet in some way and form. If it is not something where it looks like they're being coerced to do it and they're just kind of being dumb kids, we're not even investigating those. We'll either send it to locals to just let the parents know that they need to talk to their kid or something like that. But unless it's something egregious, we don't run into too many kids who are the suspects in cyber tips a lot.
Thank you. That's very helpful.
Okay, Jim.
I would just add that those cases where kids have posted stuff of themselves or a friend, those cases you've got 87 counties and 87 different standards on what would be prosecuted. And we have seen those kids petitioned in and then had to register. So, I appreciate what the gentleman from the BCA has said, and I certainly appreciate the acknowledgement of the discretion, but that isn't uniformly applied in 87 counties.
Maybe that's something that we could work towards, especially since I agree with you. I know from the National Center for Missing and Exploited Children that the self-produced cases rise they've risen every year. That's the kids' world and they don't understand. But those are not typically, it's criminal. It's not it's not harmful to, well, it's harmful to them as well as to other people who are participating in that, but it's not a crime against another person per se.
Okay. Representative O'Neill.
So for those that are in law enforcement here at BCA and maybe Sheriff Hackins and maybe even Senator Ingebrigtsen, how often do you see like a 16, 17, 18-year-old, like say 15, 16, 17-year-old, a young person, but still juvenile, that had been abused as a child, then turn around and start abusing, say like a 2, 3, 4, 5-year-old? How often do you see that cycle with a older teen and a toddler or a little bit older?
I wouldn't say that that is something we see a lot at all. We do when my investigate, just kind of just give you a case or what we do when we for like a cyber tip, if we're interviewing the suspect from a child pornography case, our agents will ask them if they were ever abused as a child, and I couldn't give you a percentage. Some of them say they were, a lot of them say they're not, they haven't been. So that I don't think it's something that's all the time kind of thing where you instantly saying someone was abused as a child, then they're going to go around and go back out and start abusing away. I don't think they go hand in hand. That's not necessarily how we look at it or how in our experience things have gone. Sometimes it does happen, but I wouldn't say that it's a predictor of some kind of offenses by someone else or if they were abused as a child or not.
Sheriff Hack.
In our work at local law enforcement, we get more child protection reports where these younger children have offended maybe against a sibling or against someone else that they know. And I also don't have at my fingertips hard data, but anecdotally, I will say that there are a number of them who have been previous victims who are now repeating this same type of behavior on the next generation of victims. So I believe I can say in our work, it does happen. I would agree with Josh that it's not a concrete predictor that everyone who is abused is therefore going to turn around and perpetrate that abuse, but it is a thread that we see.
Patty.
There is some research. I sent out a few documents that state that it used to be that was the thought that most of these kids who offend were victims, but now it can be violence in the home, exposure to inappropriate sexual behaviors in the home, internet exposure. There's a whole realm, a whole new world of things that can cause kids to offend now. It's not solely just, I mean, it's not even more likely that they were victims, that as used to be the train of thought that they were probably victims themselves. It's now their exposure at really young ages. Nobody really knows the consequences of exposure to pornographic images has on a 2-year-old and a 3-year-old, and all of that can contribute to their acting out. There's research. I did send the links to some of the studies on that.
Angie.
Yeah, I was going to say something similar with, I mean, I see it more with the sexually dangerous person cases, which is such a small percentage of the overall cases. And obviously it's the worst offenders that we see a fairly high percentage of them we see having been sexually abused, but also like Patty said, the early exposure to sex in the home or the early exposure to pornography or things like that also show up a lot in those cases. And I was actually going to ask Brian, who has his hand up, because he might know more on the research of that from a more statistic-based standpoint. I don't know.
Well, yeah, I was going to just touch on what Sheriff Hack and Josh from the BCA was talking about in terms of not a concrete predictor. I don't think we use a lot of what we call actuarial instruments as sort of the best science we have available in terms of predicting future recidivism. Now I'm talking mainly with adult offenders here, adult individuals. Can't speak as much to juveniles who were abused and then maybe it went on to offend against a family member still as a juvenile, but talking adults who commit offenses, it's not a risk factor that we see on actuarial instruments. Usually how these are developed is you have a bunch of different risk factors that you think might apply, and there's scientific analysis that goes into it, and they a few of them sort of are spewed out, and you get a 10-item tool, you get an 8-item tool, these kinds of things. Most of none of the actuarials I'm familiar with have history of childhood sexual abuse as a predictor of committing a sex offense as an adult. It's usually past history of sex offenses, stranger victim, male victim, other violence, criminality, those pieces, the age of the individual. Younger guys in general commit more crimes than older folks. So yeah, just to kind of, I think that's what you're looking for a little bit, Angie. I don't have, again, concrete studies. We can get some of this information, I think, and not necessarily just from Olivia at the BCA. They're not throwing more research on you, Olivia, but in general, studies from around the US and Europe and other recidivism numbers, we compile some of that.
I'm happy to be minion.
Right.
I enjoy research, so this is actually like, woohoo. So I am happy to pull what I can. Again, we don't have statewide statistics on recidivism for predatory offenders generally. We do have a couple of limited studies on recidivism that have come from the DOC. Those are only for those individuals that have interacted with the Department of Corrections and have been considered offenders or predatory offenders based upon their charges, based upon all of that. So I'm happy to pull what I can.
Okay, Jim.
Recidivism rates for juveniles in this area are very low. When we have these discussions, I don't have the data in front of me that I could share. Patty Wetterling may know this, but it's somewhere in the neighborhood of like 2%. And usually, most of the kids, what I've seen is that there was this belief that juveniles were, it was this cycle of sex abuse, but what it is, it's trauma that results in kids acting out in other ways. That's not only sexually, but the recidivism rate on sex offenses with respect to juveniles is very low, which I think speaks to not putting these kids on the registry.
Representative O'Neill.
Well, thank you, Jim, for saying that. That was going to be my next point of conversation is the recidivism rate for juveniles, and if we could get some, statistics and information on that, and if that's actually true that it's incredibly low, less than 2% or something. I was going to ask about a juvenile's amenability to treatment and if that's effective, but recidivism is probably an easier number to acquire than, how was a treatment effective or not. I know that I'm not sure how many practitioners there are in Minnesota that do treatment for offenders, especially in the private sector. I know of one that has done it for, 50 years probably. And I actually studied her work when I was in grad school, but she's still here in Minnesota and has since retired, but is still taking on cases. She actually took on a relative of mine who was just 2 years old when she was molested by a family member who had been an older teen, which is why the question of how often does that cycle happen. So the older teen had been molested, went through treatment, it wasn't successful, and then he molested another family member of ours. And she treated the victim. She does both victim and offender. But in any case, I think if we're talking about reforming what happens with juveniles on the registry, I think it's really important to know the story of a juvenile versus an adult predator. And I would concur with what Patty was also saying, Patty Wetterling, about the juvenile. So the idea that we used to understand the cycle of abuse, it has so much more to do with pornography. And that's something that I talked to the executive director of Breaking Free about, who obviously helps people get out of sex trafficking. And she's seeing just an epidemic, particularly of 10, 11, 12, 13-year-old boys that are watching violent pornography, not just porn, but like really, really violent porn. And then their idea of what sex is and what love is and all that has been completely distorted. And we are now raising an entire generation of young men that their entire view of relationship has been distorted. So I think this conversation is it's the tip of the spear, so to speak, because I think we're going to deal with a lot more.
So in terms of number of juveniles on the registry, I do just want to say how low it is. There's only 38 total. So there are no stats again on recidivism in terms of juveniles, because very few of them actually interact with the Department of Corrections. And so we cannot speak to their level of recidivism necessarily, at least not as an entire population. There may be studies at the federal level, but what I would ask is if those studies, if I'm able to find those studies, folks take into account that each and every state has different laws, different enforcement mechanisms, different registry standards, et cetera. So in terms of recidivism and juveniles, we can only speak to part of the picture at best.
Jim.
The question that we had at the outset was, yes, there's a small number of juveniles on the registry as juveniles currently, but they've sort of graduated onto it as adults. But they started on the registry as juveniles and are now adults. So I don't know how many of those have transitioned on, and I don't know that anybody was able to tell us.
Brian.
I was just going to say, I don't know what, following up with what Olivia just said in terms of related to the registry and reoffense with juveniles, but I just did a quick Google search and found an article. It's just the abstract, of course, at this point, but from 2016, American Psychological Association. It was published in Psychology, Public Policy, and Law by Michael Caldwell. And it really talks about, if I can just read in general here, it talks about they examined 106 studies from 98 reports or data sets involving 33,783 cases of adjudicated juvenile sex offenders carried out between 1938 and 2014. So a huge time frame. The weighted mean base rate for sexual recidivism was 4.92% over a mean follow-up of about 60 months. But then they broke that down and they said studies conducted between 2000 and 2015 reported a weighted mean sexual recidivism rate of 2.75%, 73% lower than the rate of 10.30% reported by studies conducted between 80 and 95. Implications for public policy, risk assessment, clinical services are discussed. So again, we'd have to pay $14.95 or have someone access the article in full to get
figure out how to get $14.95.
Or somebody might have access to ResearchGate or one of these pieces. If somebody goes to school somewhere, they can probably,
I will find someone.
Right, and I can send you the link. I can send you the link, Olivia.
That'd be great.
Figure that out, sure.
And then what I do just want to note is that for the state of Minnesota specifically, we have the predatory offender registry. So that is specific to sex offenses. And so we need to account for the fact that we are bringing in people in addition to those sexual crimes. So just a couple of factors to look at when I'm looking at studies in particular is the fact that we have a more expansive list than just the sexual elements. But I will do my best to pull that. Brian, if you can send me the link, I can try and figure out how to pull that for us. And then I'll pull any additional studies that I'm able to find.
Okay. Renee?
Yeah, Olivia, I know that the registry was not created for data pulls, so to say. That wasn't the intent of it. But with that being said, I believe just as Jim had said, do you have the date of first registration? Perhaps they were a juvenile, and then and pulling that date and knowing then if they are now registering as an adult.
So my understanding is no, in that we don't track people like that. We track their timeline based upon what we get from the courts, what they've done. So we have to, the registry is based purely on the need for law enforcement to find somebody where they are at right now.
Yeah.
Not necessarily their criminal history or any of that. So we don't necessarily track people like that just because it's not the intent of the registry to necessarily know somebody's history. I'm sorry.
Right. Yeah.
But again, I mean, I know that there have been a number of suggestions by folks about recidivism studies, about doing that kind of work in Minnesota. And so just know that we're always willing to figure stuff out. Unfortunately, the system at this point is just not built to do that.
Is there any intent to build a system such as that?
We do not have the funding to pay for a brand new system. That is simply not feasible. The last funding that we received was to update the system, and we have not been provided any additional funding for this work. So unless there is an influx of funding and a change in the statute that would allow us to track people as such, we currently only track those items that are in 4B of the statute. So purely because that's what the statute tells us we should track for the registry. We don't track additional items or things like that.
Okay. Thank you.
Representative O'Neill.
Well, specifically to that point, if that is a recommendation from the working group, obviously the legislature can change statute and do appropriation to cover that rebuild of a database. I don't know. The best case scenario is that there's a database already in the realm that we can purchase or adapt as opposed to build our own. That hasn't been a great success here in Minnesota. When we, the state, have tried to build our own databases, it's been kind of an utter failure. But if there's already a database in other places that we could purchase and adapt, that's a more viable option. But it could be an option and it could be an outcome of the group.
So in the past, we have built the POR systems, and we've looked at, we always do the build by comparison, and so far it's always been that we've needed to build based on Minnesota requirements, keeping the data private. A lot of these companies, you kind of feed your information into a system where other people have access. Minnesota's data is really kept private for all the right reasons, I think. But once you start feeding into these other systems, basically your file moves with the offender as the offender moves throughout the country, and no longer is it that clean file that you have. So there's some concern about the build by. The other thing I'd like to point out to Representative O'Neill, that if we do build these things, we still have that struggle of historical data and getting that up to speed with every new offender going forward. And I think that's where the concern with the data that we do have over the years, like for example, statute services was not something that the Bureau had embedded in the system that we're using right now. And so we have offenders who don't have a specific statute down to a subdivision, down to a PRIN connected to their registration file. And to err on the side of caution that we would be grabbing too many individuals or not grabbing enough is the concern as to why the data is not available because of the changes that we've had systematically over the years.
Brian.
I want to throw another piece in related to juveniles registry and in terms of people that are incarcerated for failure to register, I don't know, I forgot the exact time frame that we looked at, but we're able to pull some numbers and looked at 1,800 people convicted of failure to register that were incarcerated in Minnesota. And at that time, 22, almost 23% of them were the failure to register. The registration was solely on the basis of a juvenile adjudication. Like 23% of the folks incarcerated now as adults in Minnesota. Again, I'd have to find the time frame that we looked at, but it was 1,800 total individuals, and about 23% were solely on the basis of a juvenile adjudication. Now, those folks are not subject to community notification, just as another additional piece if people weren't aware of that. People that are incarcerated as adults for unless they commit a new registrable offense as an adult, and the registration is still solely on the basis of a juvenile adjudication, leave prison without a risk level. So they can come in for failure to register, burglary, any other non-registerable list 1 offense. And they can be 30, 40 years old. I've seen those cases too, where they're in their 30s and 40s now, coming in, still registering on the juvenile offense and not being assigned a risk level. And that, I think, is a good thing, but just getting people that are getting up there in age, still registering for those reasons.
Angie.
This is actually a key Olivia question. So, and it kind of goes to Jim's question. So when a juvenile and an adult each register for 3rd-degree criminal sex, for example, is all that you can be is that they're registered for 3rd-degree criminal sex, or do you know when you enter it that it's a juvenile adjudication? So my question is there, I know it's not regularly kept, but is there a way to pull people who are registered or were registered for juvenile offenses only, or is there not?
So the problem is, now I'm going to get way into the weeds, and I have a criminal justice degree, not an IT degree, and I have spent so much time working in these systems over the years, going back to 2000. I've been here for each of these changes. And what I can tell you is we have an offender, okay? We have an offender who has 1 registration to maybe 10 registrations, okay? Then under the registration, there are offenses. Then there are offenses that are not connected to a registration because they're failure to register. And where things get lost is we can't tell where the juvenile conviction is connected to. So in a registration, sure, in an offense, we know this information, okay? We know it's not that we don't know what we are registering people for. Like, I know some might want to run with that. Well, the BCA is just registering and they have no idea what they're registering for. That's not true. The difficulty is that the system is not built to push a button and pull this out. So what you get is raw data of Katie Myers with 10 offenses and 5 registrations. And we can't say that this offense goes to this juvenile conviction. It gets lost. What it would require is Katie Myers to go through 18,600 and some offenders and identify those, clicking through to figure out of all of those registrations, who's what one's a juvenile. Now, I suppose we could, and then we also have the other problem is that button to say this is a juvenile conviction was not there years ago. So that might have only come on, let's say, in 2014 when we moved from the old access database that we used back after Katie's law got put into place, that we had to move into 2014 because the access database just couldn't hold the records, and it wasn't, there were, it was a different mechanism security wise that they had to upgrade it to the current system. So that's where the hesitation is that we have no way of saying, show me juveniles and then show me that juvenile conviction is connected to this. Because if they have multiple, now we could say if they have only 1 registration, only 1 conviction, and that's for a juvenile, we could probably come up with a number. Again, though, only for those that have that information populated. The older the offender, the potential that it's not populated. If they completed off as a juvenile, we probably wouldn't have that if it was old back in 1994 when we added juveniles, because they would have completed the process. If they did the 10 years, they would have been done in 2004, and we wouldn't have that record.
Because that's what I think, actually what you say you can't get, I think would be kind of what would be interesting, because the question is, okay, like, well, one of the questions is, okay, so there are like 30 some whatever juveniles right now on the system. But how many, I wonder if you could say, you know, since 2000 or whenever you would have good data, we have this many offenders who are registered just for juvenile adjudication. You know what I mean? And the thing is, you wouldn't care about, those juveniles wouldn't be included if they had these later offenses, right? Because you only want to know the ones who are only registered because of that juvenile adjudication. Does that make sense?
It does. What we would lose though, we would lose any juvenile offender who, let's say, has been convicted of an adult FTR. That would get lost, where they still only had. So these are the complexities. Like I'm telling you, I have spent hours and hours racking my brain trying to figure out every scenario to pull this, because I want to be able to provide it for you. I absolutely do. But every time I stop to think of something else, it's like, oh, here's one more factor that would skew this number, and we just don't have it. So I'm happy. I will pull that one instance where that juvenile conviction is shown once. But I'm giving the caveat that I can't guarantee that's it, because I don't have a concrete date of when everything would be populated for somebody. So I could just say, this is what we have, but you need to know that there are other juveniles that have a one-time conviction that aren't going to show in this, that probably had completed before we ever even got to the system that we're in today. And we never go back and populate old offender information. We don't have the resources to go back and say, oh, this guy completed or gal completed in 2004. We're going to go in and check the box that says same, like whatever. Here's the statute, because they're done. We are actively working. We're trying to keep this information up to date. We get so much information on a daily basis, and we need to follow what the statute is telling us to do in keeping these offenders compliant, and Sheriff Heck doing the important work that he does in keeping them compliant.
Hey, Jim.
Usually my only experience is on knowing essentially what the BCA has is when I get a failure to register case. Of course, it's alleged in the complaint what the basis was for the registration, and then in the discovery is essentially it's the BCA documents that show what the client had to register for and why, which would be introduced as evidence in the failure to register case.
Correct.
I agree with Brian's analysis that it's about 20% tend to be juvenile registrations. I mean, I don't have the data in front of me, but I would say, a fifth of them are juveniles or juvenile registrations.
So again, I don't think we can answer to stats on this, because again, we're tracking individuals and where they are at right now in whatever process, in whatever registration, et cetera. So there is no way to cleanly pull, as Katie said. These are all individual cases, individual scenarios. So I'm not sure that we can provide stats regarding that at all.
Let me see. Representative O'Neill.
Thanks. One way that you could consider getting some stats is just doing a limited sampling of the 18,000 since it is just a case by case, maybe pull 50, 75, 100. I don't know if you've got somebody the resources to be able to do that, but I mean, it's just an option instead of saying, well, I'd have to individually look at 18,000. Just pulling a smaller sample size and just see out of the random sample what kind of numbers that you got for juveniles. So they were convicted as a juvenile and put on the POR as a juvenile. And, you know, kind of like what Jim was saying, it's an option. At least we would have some kind of data as opposed to anywhere from 2% to 20% to, we have no idea. At least it would be a random sampling of the 18,000.
So we as the BCA do not have funds to dedicate staff to sorting through. Our folks are literally booked solid, tracking, you know, investigating crimes, et cetera. I think the concern with pulling a limited sample would be that it would not be reflective of the entire population that we are analyzing here in the working group.
Well, as Brian mentioned, when he talked about those failure to register who were committed to prison, representing 22% solely based on juvenile registration. That actually is kind of reflective of what Jim mentioned also. And that should be a fairly accurate representation, at least for failure to register alone.
And I'd like to point out, when we start looking at statistics from the Department of Corrections, again, the majority of our offenders, based on the very first presentation I gave, do not have risk levels, meaning they have never crossed the DOC threshold, or at least have not since January 1st of 1997. So we have none of anything that we are looking at through the DOC's eyes are not including that majority of offenders currently on the registry. So we want to just kind of keep that in the back pocket, I think, to know that that group is not part of the percentages that people are throwing out.
Patty.
Well, since we spent a majority of the last hour discussing what we can't get, when we passed sex offender registry in 1991, was it? We were criticized because we were challenged. You can't make it retroactive, so it's a ridiculous thing. It's only going to go from this day forward, but at least we knew that we felt we needed to start. So to me, one of the recommendations that should go back is an evaluation system. We need to build. What are the questions we want to know whether this is working or not, and how is it most impactful, and what could we do instead of reincarcerating somebody for failing to register? Could they go back into treatment or do some community service or something other than the costly incarceration step, which may or may not be effective? We don't know what's working and what's not without data. So I would suggest that we write down what we want to know and build that into a recommendation. So going forward, and it might not have any impact for 10 years, but 10 years later, we're going to be able to answer some of these questions, because it's frustrating. I hear your pain in trying to draw out information that was not designed to do, but we can build it so that we'll know whether we have a meaningful tool, what's working, what needs to be tweaked going forward, because I really think that's what's missing in this equation.
Sheriff.
Patty stole just the majority of my thunder there. I'd add on to that comment that I would agree that if we're going to make database decisions to changes in the statute, that we really need to either be able to access all the data and have confidence that the data we're spitting out represents everything, or we need to fund some type of a study that's done in a professional and rigorous manner, according to standards that are out there. I'm sure that there are people that could do a good study for us, and I would just hate to see us make decisions based on incomplete data, thinking that we're actually using good data points.
So there is an ability for researchers to come in and look at stats I believe I mentioned this yesterday in response to a question. These private data can be accessed by researchers for research purposes. It can be pulled for summary data purposes, et cetera. We would obviously need any researcher to sign a non-disclosure agreement so that it went solely into actually researching and providing a report. But it is legally acceptable for researchers to use this data for the purposes that you're discussing here. Representative O'Neill.
So this might be a really fantastic outcome of this, which is the legislature could commission that study, pay for it, look at all of the data. I mean, if you really want to rebuild the database, possibly do that as well. That could literally be the only outcome that we have. If we want to make fact-based and database decisions. And it, you know, as frustrating as it is, it's really difficult to make decisions at the legislature without data behind it. And if we can't achieve that and can't obtain the data, then maybe we need to just take a step back and just let the legislature know that we simply don't have the means right now to make those decisions.
And I just want to say, believe me, we want to be able to pull this. We do. It would solve so much for us to be able to pull these stats and have these conversations. Our struggle is with the fact that the system was never meant to pull. And so each and every case individually has to be sorted through, just like it would be when we go to Angie for her opinions on things. Our apologies that we aren't able to provide what folks are asking for. Believe me, Katie has been racking her brain for weeks now, trying to figure out how she could get through all of this stuff. So I just want to apologize that we aren't able to do so with any level of quality assurance at this point.
And as far as speaking on behalf of the legislature, no apologies necessary. I just think we just need to face the reality of what information is available and what isn't, especially when you're talking about the time frame we have. We have so little time to really reform a very controversial and very sensitive piece of legislation or of data, excuse me, of statute. And so I'm very hesitant to move something forward until we have deep discussions, good data, all of that. And it just isn't, it's not fair to people that are on it. It's not fair to people who will be on it. It's not fair to law enforcement. It's really not fair to anybody that we try to move something forward quickly without really good information, honestly. So no apologies necessary. It's just a reality of where we are.
Yeah, and like I said, we will pull whatever we can, whatever we are able to. I believe that Angie was up next, but correct me if I'm wrong.
I think
No,
Renee.
Renee.
Oh, Renee, I'm so sorry, Renee.
No problem. I'll go at this one more time, and you may think that I'm crazy, but have you thought of this? And you possibly have, Olivia and Katie. Have you ever thought about like a menses pull? We pull data from menses into CSTS. You know, it populates things for us. I'm just wondering about a menses pull of a date of a first conviction, you know, bumped against a date of birth, and pulling that data and then cross-checking that with who is still registering today. Maybe way out there. I'm just trying to think a little bit outside the box to maybe pull some data.
So the one thing that I do want to mention, and unfortunately, the judiciary had to sign off because the BCA double booked her, sorry guys, was that there were concerns from the court that were expressed, I want to say yesterday morning, about the fact that they might have multiple people under different names. So like, for example, I'm Olivia Christine Anderson. I'm also Olivia C. Anderson. I'm also Olivia Anderson. And so there were concerns with regards to being able to pull cases like that. In terms of Mincis, I can't speak any further beyond that. That's all I know of. I am no expert in terms of Mincis, but that was one issue that I recalled the courts expressing concern about. Yes.
I would think though, that as kids, that would be less likely to happen.
And so why don't we talk to the courts about it? It sounds like we're gonna need to chat with the courts about what's feasible and see what we can cross compare.
And well, and like I said too, I'm gonna look and see what I can do as far as a one entry, one juvenile conviction. But again, I wouldn't bet my life on what would be produced, because we're gonna miss those old instances. But I can give you what we have at best, but again, it can't get put in stone and say, this is a concrete answer. And I'm guessing the same thing would come from the courts just as well. Because I had brought that up to Olivia too and said, could this be a pull from the courts? And she reminded me that the courts said too, they have the issue. And I know I see it in our files just as well. There'd be something that says this offender is in, Mincis as this as well, or only this. Like we see that where, like Olivia said, their middle names on some, they're not on the other. And, they kind of end up with multiple court files or names in the court. So we'll do the best we can, Renee, on this end. We'll also talk with the courts and see what we can, what they can pull.
Because I'm thinking,
go ahead.
Go ahead. I was also thinking that if it's 33 juveniles on per year, so to say, we know that continues on. It might not be as tasking if you compared that to who's on the registry now. So I just want to throw that out there to maybe get some data in respect to that. And if the group finds that that's not valuable, that's fine too. The other comment I just want to make in respect to Jim's note on the side is that looking at those lower level convictions and that registry, I think is important for us to look at too. Like their length of time to register, or perhaps, again, I'll go back to the petition to register. So I just wanted to make that comment also, and lining up again with Jim in his comment. I kind of interrupted you, Olivia. Did you have something you wanted to say?
No, I just really appreciate everybody being so willing to chat through the data and chat through trying to figure out and brainstorming with us. I do know that when we think about it for 6 weeks at a time, we tend to end up a little bit overwhelmed. And so we will do what we can and speak with the courts about what is feasible. I do know that the courts have stated that pulling any kind of grouping of data on everybody would require the same, would require some kind of study, et cetera, regarding recidivism, if that's what folks are looking for. But I want to just be sure of who was next. I believe Patty was next.
Angie, actually.
Dang it. Okay. Hi, Angie.
I wanted to let Renee know, just based on her comments now, that the extensions and that are something that we're addressing in one of the other subgroups. And this group is a little bit into the crimes part too, but I just think it's hard to look at process and not kind of bleed over into the other issues too, from a fairness standpoint. But, and that's the other, I guess, point, the reason I raised my hand is, and I think I have been paying attention to the chat, although one of Jim's comments briefly popped up. But I do think that while we should say to the legislature, we don't have the data on this, and these are the kinds of things that might be helpful for the state to know. I do think we can look at things from a policy and fairness standpoint and say, from a policy and fairness standpoint, maybe this process would be helpful, or something like that. So I still think, a lot of legislation is passed on policy versus data or some combination. So I think we still should do our best to make the best recommendations using what we have from that standpoint. And part of that, it sounds like might be, gosh, would be great if we could get some better data for the future.
Patty.
And I don't want us to not go forward with what we believe needs to change. And I do know there's research on the harms of putting children on a registry. There's national research and data showing that. And I would really like to see, even though it's a small number, I would like to see going forward that we not register juveniles. It just across the board, there's a nationwide effort to do that. And I will send, as I become aware of more activity and more research, but I've sent out some of the studies, and I just think that's, although we don't have all our Minnesota data, when these offenders got put on and were they kids and we could stop that, that even being a problem by not registering juveniles. I think that's just, my heart tells me they're not the same as adults. Their brain's not the same. Their reasoning's not the same. Their exposure to all of these harmful things which cause bad behavior, they didn't get to choose. They were born into a house with violence or drugs or porn and inappropriate stuff. And these kids deserve to be treated differently than adult offenders. Thanks.
Brian.
Just going to mention again, we're getting related to the data piece of it. First of all, I agree with Angie and some of the others about still making recommendations based on policy changes or things that we do have based on data we can get in this 3-month period of time. But if we need additional data, again, like Representative O'Neill said before, and to do additional research, it's likely going to take longer than the 3-month period of time. We have, I don't want to necessarily make any volunteer anyone, but the DOC's Planning and Performance Unit has been doing research for a number of years. We have, published studies all over on a variety of different things. But from a resource standpoint and things like that, it would take time. I know we've accessed BCA data for those purposes in the past. And so that would just be something that is a possibility moving forward. And I think we could get some good data. Like any research, and I think Representative O'Neill said this as well, it doesn't necessarily need to be all 18,000 people. It's not, if you have complete data sets on everything, that'd be great. In most research, that's just not possible. So you do use randomized samples to get what we would consider to be a representative sample of the 18,000. Maybe you pull 1,000, 2, 3, whatever that number is, happens all the time in various research. So I think that's something, again, from a time perspective that we might have to look into the future at.
Representative O'Neill.
Yeah, this has been a really good conversation, and I am so appreciative to this group right now. Just in listening to all this, I just have a few kind of closing thoughts because we're kind of getting close to the end here. I think one thing that we could discuss at great length without the data is a process of a petition to get off the registry. I think that is an absolute important policy piece, as long as we figure out what are the parameters. I mean, that's going to be obviously the most important part. As to the data, I'm wondering if possibly anyone has connections to the University of Minnesota. Maybe we could get an intern from their math department or something and have an intern come in and look at some of do a randomized sampling of the data, or other researcher. Just an idea to have come in. And I don't know how much they can get done in 3 months. It might be a little bit short. And then the final thing I think that keeps coming up over and over again is whether or not we even want to put juveniles on the POR. So that's a policy piece that we could discuss that is, I don't know that you need data to make that policy decision, but I would recommend that we at least discuss those things. So whether or not we even put juveniles on the POR and some sort of off-ramp, a petition to come off of it. And I think that might be some helpful things. And then does anyone here have any connections to the University of Minnesota or other institution that might be interested in coming in and researching and taking a look at this data for us?
So a couple of things about this is that it is going to take a significant period of time just to train someone to use, understand, and work with the system. So about half of that will be gone. And that's just the nature of the beast. I can talk to Drew about what is feasible for the, Drew is our superintendent, about what is feasible. We don't want to write anything off. We just want to be sure that whatever is coming out of our system, we can guarantee is accurate. That is our number one concern, is accuracy. Because we don't want to provide misinformation and have the working group run off of misinformation. We can have a discussion with Drew about what is feasible. I'm sure he has connections to University of Minnesota and others. But please know, we really, really are concerned about the ability to make a decision based off of a small sampling that could affect 20,000 people.
Renee.
Yeah, Olivia, if you have a connection, great. I know Hennepin County has partnered with the U of M and they've done some research for us. I can wait to hear back from you if you would like to check into that first, so we're not duplicating our efforts. But we've had great success with them.
I will assault Drew today. So I will find him today and get a hold of him and chat through him with some of this stuff, and Katie and others who know the data system better. I will say that our number one concern remains the same, regardless of whether it's an intern or anybody else. We want to be sure that folks are getting accurate data, especially when it comes to making permanent policy decisions that will impact tens of thousands of people, if not the entire state. So when we talk about a small sampling, that makes us very nervous, to be honest with you, because it's not going to be reflective of the entire pool, regardless of the number.
In addition to Representative O'Neill, the concern, like I said before too, is that we don't have all this information populated on the entirety of the offenders. And so even to pull in, somebody not connected, as like I said, I've been dealing with this information for many years, bringing somebody in with a different skill set isn't going to make the data appear in here any easier to them, or have those offenders that are missing some of that data all of a sudden have it in there as well. So it's still that same information could be missing. They're going to still have those internal struggles that I have every night when I think about this information, trying to pull, no matter where the pendulum slides, if it's, we have too many of this or we have not enough of this, whatever it might be, they're going to have those same struggles as far as weighing in that information and when it's missing on some of these older files, let's say, or the ones that haven't been populated with some of that data.
But in summary, yes, I will talk to Drew and we will figure out what is and is not possible. Again, there is no way that we can guarantee accuracy without folks doing an actual research study and going through all of these files and going through all of these individuals. And that's just not feasible for us to do in this period of time, especially when we're talking about historical data.
And we talked about yesterday too, there's a whole, and Representative O'Neill, I think you were on that, because you were on all of them yesterday, right? There's the whole group of closed files or inactive files, and how do you want to factor them in and all that. So that's in addition to the 18,000 whatever. I can't remember what the total was, but it was like 30,000 maybe or something. Maybe it's 20 something.
There are 33,000 total files.
Okay,
in
Brian.
a variety of formats, historical and current.
I just want to reiterate it. I mean, I agree with Olivia in terms of the need to do an actual research study that's rigorous and, covers everything. But again, we don't need to necessarily look at all 33,000 files or all 25,000, whatever it is. We have a representative sample that's used in research all the time. It's a smaller sample that represents the larger sample as a whole that adequately represents that. So we're not talking like 25 people or things like that, but a smaller segment of larger sample that adequately represents that sample to make those decisions. I think that can be done. Happens.
And our issue is, how do we choose the representative sample?
It's
We
a
have
randomized.
18,000 files that we need to figure out are representative to begin with.
And with 33 juveniles currently, Brian, how would you get it represented, a good look at that data when we have 33 active juvenile offenders?
So I think, and I'm not a researcher. I mean, I've done enough, in grad school and a little bit beyond and read research all the time, but just in terms of randomized sampling, our planning performance unit, Grant Dewey, we do it all the time. We pull random samples of that 33,000 and there's control, there's factors looking for extraneous variables that may, affect that particular sample and things like that. And so just like anything, it's not going to be unless you do have every sample, every person in every location, that would be ideal. And it's just not usually how research is done. So
let's
random sampling, controlling for some of those extraneous variables, I think is how we would do it. If we get
Yep. And our struggle is we can't even pull randomized out of the system.
Yeah, let's.
So yes, Representative O'Neill. And I know we're closing up here. Sorry, guys.
Yep, so the last question I have, just to think about, and we can talk about this next time, is what do we need the data to tell us so that we can change policy? Specifically, what policies or policies are we looking to change that we need the data for? And what can we look at doing without data? I think that's something that we should make two lists of what can we change? What do we absolutely need the data for to make a policy change?
And we are happy to, if there's a list of data that you find necessary or that you need us to work on, I think part of our struggle is figuring out how to prioritize some of these requests and what is best. So if the group tells us what they absolutely want and absolutely need, and we are able to figure it out, we will figure it out. We will do whatever it takes. I will personally sit there and type up stuff on my own, but we need to figure out how to prioritize it as well. So I totally understand. And I know that we are closing up here. I'm so sorry that this data discussion has kind of taken over everything, but it does sound like it was of value for folks to kind of chat through what would be beneficial. A couple of things before we close. One, awesome discussion. Two, for the schedule. I've said this in other groups. I want to be sure to say this here again. This is going to be our standing schedule unless we hear from folks either at the meeting before or in advance that things need to change, that the meeting isn't going to be useful this week, that you would like to be doing other things during the week, et cetera. Otherwise, please feel free to contact Mark and I, and we are happy to do whatever we can to accommodate folks as best as we are able. Recordings of these work groups will go up on the webpage as they always do. So if you do miss one, please go to the webpage. That will all be readily accessible to you all. Any data that we do pull, we will send out to the group as we are able. Again, please use Mark and I if you need anything. I will pull what research I am able to find and pull as quickly as I can. I will get that to the group as soon as possible.
And we want to make sure we fit in this piece with public comment, just in case Mary wanted to speak in these last couple minutes. if you raise your hand, if you'd like to, otherwise we'll go to Representative O'Neill. So Representative O'Neill, next.
Thank you. No, this has been the best subgroup meeting that we've had so far. It's really got in depth. And I think I would encourage everyone to, in this next week before we meet again, to really think about the data and what do you need the data to tell you. I think we need to just really narrow the focus as to what you need the data for to change policy. And I had already mentioned a couple things of policies that we could discuss and consider changing that probably don't need data. So just to reiterate that so that we can hopefully discuss that next time. Do we even put juveniles on the POR and then coming up with some sort of an off-ramp petition to come back off of it? So I think those are two things that we've consistently said throughout all three subgroup meetings. And hopefully we have conversations regarding those in the next couple weeks.
Okay. In the last 2 minutes, is there anything else? Renee.
Yeah, Brian, I'm wondering if perhaps maybe a starting point might be for offenders that look for that risk reduction and the criteria that they have to meet in order for them to go forward with that process. That might be a good starting point for us when we're looking at like a petition and the criteria that they have to meet. Just a suggestion that instead of us trying to brainstorm, we may have something to work from for next time.
Yeah, that would be something I'll send to Mark and Olivia, just the criteria. Some of it's statutorily required, some not. So yeah, I can do that.
Awesome.
Okay, Angie, let you
Well,
close out.
Thanks. And just a reminder that there was some proposed language that we should at least look at. And that also can be a starting point in the from the Criminal Sexual Conduct Reform Working Group. It's at the end of that attachment.
And the report is on our webpage if folks need it. And I believe that the relevant section is subpart 2.
Yeah, it's like pages 3 and 4 of the 4 pages. Thanks, everyone. Have a great rest.
Thank you.
Thank you.